Can I first of all say it's a great pleasure to serve under your chairmanship, and I'm going to truncate my remarks because of other people wish to speak. I don't wish to, as it were, trump the honourable gentleman for Swindon, but I have 35 years' experience of the law in family matters and crime, both publicly and privately funded. But I have to say to him that most of what he says I totally agree with. And obviously when people agree across the House, there's something to worry about, because there's a problem. He's laid out some very important facts in what he had to say. He's a member of the Justice Select Committee, as I am, and he's made several points that I was going to make. But I really do wish that the government would slow down. Many of these changes, including this one, are being rushed. They're being rushed without, in my view, adequate time for real consultation. Yes, there have been 5,000 consultees and so on, but it's been a rush job, and it's been one which has left a real fear out there. Desmond Hudson, the Chief Executive of the Law Society, for example, says, if the government persists with these proposals, it would represent a sharp break from the long-standing bipartisan consensus that effective access to justice is essential to underpin the rule of law. And to that I say hear, hear. But I'm very concerned, and I'll confine myself, due to the time constraints, to the whole issue of family law. I recognise there are problems with immigration law, there are problems with welfare law, housing, and many other parts of the, as it were, social welfare legal system. But I'm going to confine my remarks today to the whole issue of family proceedings. And as was said, there is a mistake, I think, albeit one of these with consequences that weren't imagined at the time. But the way in which the qualification criterion of violence has been framed, to me, is utterly unworkable. And as a practitioner, the same as the Honourable Gentleman for Swindon, I've seen occasions where accusations are made for various reasons, but it is absolutely sure as I'm standing here, that there will be accusations of violence being made simply to avail themselves of a legal aid certificate, being the only way that they would be represented. And the other things I have to say, the thing I have to say is, quite clearly, victims of violence may be brought to court by others seeking to continue their control over them. So as the Honourable Gentleman says, we need to look at the definition. It's abuse, it can be mental abuse, it can be all kinds of other dominant abuse by not always male and female, but mostly. And a situation where there's, to use European parlance, an inequality of arms. So in effect, that will also mean that if somebody is able to afford a lawyer and the other party is honest enough not to say that there's been violence, the other party will not avail herself, probably herself, of any assistance. And that, to me, it has to be wrong. I accept, by the way, that mediation is a good step forward in some ways. It's been tried for many years in a great number of areas, as far from us now as, for example, multi-million-pound shipping contracts. It seems London is the mediation capital of the world. Good luck to those lawyers. But this is an entirely different kettle of fish. I've received dozens, if not hundreds, of letters from individuals, from lawyers practising in this field. And let me just make this point. Every time a lawyer makes a claim that loss of legal aid will mean damage to the public, it's always thought to be special pleading on behalf of the lawyer. Let's cut to the chase. Legal aid lawyers haven't had an increase in their fees for the last 11 years. So actually, if you want to become a fat cat, you do not open up a legal aid practice. And I suspect, although he should not get involved, that the chairman knows that as well as a lawyer himself. But anyway, I make that point. It's not a question of special pleading or self-serving. It's because these people are dedicated to providing the service. And if any person has been in court when there's a question of a family being broken up permanently, inasmuch as one party will never see the children again, and I've been, it is a very fraught and emotionally charged situation as well. Yes.
These proposals also rely on judges, chairmen of tribunals and magistrates having the time to give advice to litigants in person? And does the honourable member agree that that time simply does not exist? Judges already have back-to-back lists. And just to give an example, in my county of Kent, there's already a 5-month waiting list for a parent who has been denied access to their child to see a judge. That is totally unacceptable for any parent.
Yes, that's absolutely right. And that is partly because of judges' time, but it's also to do with Kafkas and various other things as well. But the Honourable Lady is absolutely right. And let me make this other point. If a person seeking legal aid in order to protect his or her relationship with his or her child is denied legal aid, they're not going to walk down the road and say, well, tough, that's it, I'm not going to have anything done about this, so I'll walk away. That person is going into court, very often without the expertise and the knowledge, perhaps, and the learning to do the job properly, even doing himself or herself down in the circumstances. As I think it was Sir Nicholas Wall who said when he gave evidence to the committee, with a matter such as a child, people don't give up easily, nor should they. Nor should they. And the other point is he was making, and others have made, the courts will be flooded out with litigants in person. And any conceivable saving the government are looking at now will be swallowed up with that heading alone, let alone anything else. And we know under the Children Act 89 of the no order principle. It's going to be driving these people to go to court in order to ensure that they do have contact with the children. I would urge the Minister, by the way, as some kind of a backstop, to look again at the Family Law Act 1996, Section 64, for which I was responsible, and that would give the children independent representation, because nobody in this room, I believe, nor indeed anywhere else, would want to see the children suffering, because really that's what it's all about. When parents break up, they might throw things at each other, they might do whatever they want. Ultimately, the damage is done to that young person or persons in the middle. And I would not want to stand by idly and see any protection for that sector of society not being properly looked after, because otherwise anything short of that is downright uncivilised in my view.
Would the member give way?
Very briefly, because others wish to speak.
Thank you, Honourable Member, for giving way. In my experience as an elected representative over the last some 30 years as a councillor and so on, we have found that those who need legal aid most are those who come looking for it. Is it the Honourable Member's experience as well that if we're not careful here in the changes that the government is proposing, that we'll have a two-tier system, those who can afford it and those who can't?
Well, I'm sorry to say that is exactly the point. That is where we're rapidly reaching at the moment. One might argue that we're already there, but it's going to be a situation where some people will get access, others won't. And that, again, is abhorrent. We're all equal before the law. We're all entitled to have equal access to the law and to the procedures of the law. It appears that these measures will limit that scope definitely, and there will be more. There'll be a law for some and not for the others. So I would urge the government again to look once more at this particular area. I'm not going beyond the idea, beyond the changes in family law for obvious reasons today. But I would say that Nagalro, for example, who, if they don't know what they're doing, nobody does. They say the changes are premature. They believe there's no sound evidence base for them. And they also believe that the children have not been considered as stakeholders for the purposes of impact assessment. I would merely say this in conclusion. I refer to page 71 of our report. The main part of that has been quoted by the Honourable Gentleman for Swindon about domestic violence as a criterion. I'd urge the government once more. The Minister did say, in fairness to him, before he came, when he came before the committee, that he would look again. With respect, he's had time to look again. Will he tell us today whether he's got a better definition which will not, in fact, work against the best interests of the children we're all here to protect?